All I want is to get to Chicago, you know? And I just can't. This story keeps sucking me back in, much like Jane Doe keeps sucking in The Bachelor over and over again. This story continues to not disappoint. But I'm like, my face is dry. I forgot to add my moisturizer after I got out of the shower, and that's really going to bother me because as I'm talking, it's going to start like, you know, because I forgot to put the face oil on. Yeah, oof is right, IT goatee. Oof. This is a jammy stream. Welcome to the ASMR chill stream on the Megan Fox show. Is this story going to knock you up with twins? Quite possibly. I can't take the liability there. You never know what's going to happen. But I am reaching for a nightcap. Oh my god, am I going to kill this bottle tonight? This has been up here for a while, but I think I am. Yep. There goes another one. All right. Where's the trash can? All I'm trying to do is get to Chicago to support my friend, and then I get emails with documents that just dropped. And oh my god, it has to be talked about. We have to do it. Yeah, no moisturizer. Shoot. Are sweats allowed on Rumble? Absolutely, sweats are allowed. I mean, I'm wearing my Walmart special jammy shirt. I don't know if you've been to Walmart, but they have these jammy shirts and my bathrobe and a glass of whiskey. So that's really all you need. And I also have water here because I need to hydrate before I fly tomorrow. Mm-hmm. Jingleberry says, we twins now have to introduce ourselves as I'm a twin. Fraternal, not fellatio. Reddit is very upset with me again, by the way. Again, the Justice for Clayton, and not the mods, by the way. The mods are cool. The Justice for Clayton Reddit page, there are some people who post on it who really dislike me. And it is funny as shit. In fact, the most recent thing that they wrote about me should be used as an advertisement for this show. Let me just pull that up for you because I don't know why they keep giving me this material. Listen, Reddit, as long as you are giving it to me, I will use it. That is my promise to you. Okay? Look at this. Oh, wait, I need my Reddit voice.
Wait, hold on. Can mods address allowing these links to be posted? I watched the live just to check it out, and I'm absolutely disturbed. Unless a video of Megan Fox is going to fully focus on the Clayton case, it seems entirely inappropriate to allow links to a live where the host is going off topic. A few things. Made a Monica Lewinsky blowjob joke.
How dare I? It's like the oldest joke in the book. Dude, it's the oldest joke in the book. How can I talk about blowjobs at all without mentioning Monica Lewinsky? Now, I have a lot of empathy for her. That girl was used and abused. I have no beef with Monica Lewinsky, but it is true that in the 90s, a blowjob was referred to as a Lewinsky. So that joke is completely relevant and also fair. Just saying. But I really do think that this is like the greatest recommendation for this show. We're not done. We're not done.
Called Meghan Markle. Of all the attention-seeking wenches, she's one of the worst. All because she practices calligraphy. Like how absolutely unhinged to call someone an attention-seeking wench because they like calligraphy. Some odd reason compared Amber Heard's handwriting to Jane Doe because some handwriting expert claimed that their initial impression of the napkin handwriting was a woman who has the maturity of a 13-year-old, low self-esteem, and low intelligence. So somehow Amber Heard is relevant?
You guys, I can't. It's so funny. It's so freaking funny. All right, hold on. I didn't close my wall. Hold on. I need to close my wall. All right. The Wall O office is now closed. There's a little bit more.
I don't understand how these comments are relevant to anything and how these are appropriate for the sub. This is about justice for Clayton.
Well, yes, ma'am. It is. And if we can't joke about it's funny how she doesn't have anything to say about Dave Neal's repeated fellatio jokes because he has told many. I mean, many. And I laugh at every single one because they're really funny. And but I am not allowed. I'm not allowed to tell those jokes. But listen, Reddit, please keep this up because this makes my day more than anything you can possibly imagine. It makes my day to read these comments. I will somehow put these in like I don't know, some kind of Google review for my show. They're just so funny. And one of my followers on Twitter was like, "Oh my God, now I have to go listen to trad wife Megan Fox tell blowjob jokes. I did not see this on my bingo card." This is good stuff. Good stuff. Oh, the printer is printing. My husband must be printing something. He's going to be in here in a minute to come get it. Oh boy, that's a loud sound. All right. Print them out. Legal Vices says, Legal Vices is at work, or he would be joining us right now because he's going to love these documents. Print them out and wallpaper your bathroom with them, Megan. That would be funny. I mean, I love them. I literally love these Redditors. I love that they get so triggered by me. I don't know what it is about me that triggers them so much, but it's funny as heck. All right. Thanks, Unhung Hero. Chicago is gay. Yeah. And also pretty dangerous. But I'll be in the burbs. It'll be fine. Unhung Hero says Reddit is in their fellatios. Oh, that's funny. Fellatios. I get it. All right. Moving on to the documents. Sorry, that printer is loud. And it's like, how many pages is this going to be? It's like 800 pages. Hold, please, while the printer is printing. I got to pull up the documents anyway. I wasn't ready. I was busy making food for Archie Ruckus, which is something I'm going to make on Locals on a cooking stream one night. It'll be fun. So I started making the farmer's diet on a budget. Because, they have that dog food you can order and it's like all natural food. Well, guess what? You know where you can get all natural food? The grocery store. And it turns out that all these people are making this stuff on YouTube. Do I have stuff in my teeth? I feel like I have stuff in my teeth. I don't know. I can't tell. Anyway, I started making it. And oh my God, the dog loves it. So now I can't stop, of course. And it's going to make his dog food last a lot longer. All right, opening documents. God, this is so good. You're going to love this. I am going to read it to you in the order that it was received by me. Okay, it sounds like the printer is done. Oh, you can barely hear the printer? That's funny because I can hear it loud and clear. If you can't handle blowjob jokes, you just shouldn't internet. It's not for you. I agree with this. And I mean, how could I cover the fellatio tonsil twin story without ever making a Hummer joke? I don't know if that's possible. I mean, I feel like even my mother would approve because how? How could it be done? I don't think it can be done without jokes. Legal Vices says, how could you not see Megan making blowjob jokes on your bingo card? That should be a free space. I totally agree with this. That should be a free space. Does somebody want to quickly mock up a bingo card for tonight's reading? Locals, you want to get on that? Locals, where are you? Hold on, let me pull. There is a Locals chat, by the way. MeganFox.locals.com, members only Thursday live chat. It is hopping right now. Can anybody mock up a new bingo for tonight? Because we may need that. Please put Megan blowjob joke on it. But we need a new one because we're gonna come across some crazy shit. Okay? Think deposition, no-show, lawyers' emails. Oh, there's so much. Next time you use I didn't do the printing, trophy wife. It was Mr. Fox, and it's still printing, by the way. And now it says, uh-oh, color cartridge depleted. He's gonna have to come in here and fix the color cartridge. I think I better text him and tell him. Hold, please. All right. All right, Ginger with the soul on locals says, okay, who's making the bingo card? Any one of you, just get to it. Let's go. We need to get it up and running so that we can have it available to check off the spaces when we are, as we go. All right, let me share this document that we have here. Present. What am I doing? I prematurely hit the the pause button on the hold music. Ah, there we go. All right. In the Superior Court of the state of Arizona, in and for the county of Maricopa. And oh, for those of you who don't know, she did not show to her deposition. And that's what this is about. Okay. This is what it's about. Yeah. Have you hit that like button yet? If you haven't, you need to, because I wasn't even supposed to be here streaming tonight. I was supposed to be packing for my trip tomorrow. I'm supposed to be doing other things, but I couldn't not be here to read these for you. So, say thanks by hitting that thumbs up, whether you're on Rumble or YouTube or Facebook, if anybody's even there. I don't know. All right, here we go. This is, I'm going to make this bigger. But if I am big in it, I won't be able to see locals. Maybe I need to move locals. Let me move locals onto the other page. There we go. Now I can see you locals. Okay. I got to move shit around. Respondent. Oh, this is a notice of non-appearance at deposition pursuant to Rule 57G, assigned to the Honorable Julie Mata. Mata? I'm not sure. Respondent Clayton Eckert by and through underside counsel and pursuant to Rule 57G, Arizona Rules of Family Law Procedure hereby notifies this court that petitioner, Laura Owens, failed to appear at the properly noticed deposition scheduled for January 17th, 2024 at 1 p.m. Now, that was yesterday, and she didn't show. Counsel conducting the deposition was notified the day prior to the deposition that petitioner was not going to attend. Petitioner and her former counsels. I like how S is underlined. Do you see that the S is underlined? This is lawyer speak for judge. Please notice that her counsels are many. She's had several lawyers on this case. He underlined just the letter S. I see you, Greg. I see you, Greg Woodnick. I see what you're doing. Those of us who write for a living, we notice these things. Petitioner and her former counsels were previously noticed and agreed to the date of the deposition on or about December 28th, 2023. Notably, when petitioner obtained new counsel, she did not request an extension of time. Oh, crap. You know what I forgot to do? I forgot to put this on Twitter. And you know what that means? If I didn't put it on Twitter, that means Reddit won't be here hate watching. Shit. Well, we have to remedy that right now. I got to put it out on Twitter. We're going to put it on Twitter. What is that clip Nick always plays? I don't give a shit. I'm going to put it out on Twitter. That's a funny clip. I need that. How do you know Reddit is here, Saint Dodo? Is that you? Are you Reddit? Hold one moment, please. Please hold. Please hold. All right. Justice for Clayton. All right. All right, now we can get back to it. I have alerted the world. I'm sorry for the whistling. So my best friend, the one I'm going to see in Chicago, she hates whistling. Like if you whistle in her presence, she freaks out. She hates it. So my best friend, like all through high school, like this girl could not stand whistling, and it was so funny. If you want to freak her out, all you have to do is start whistling. That and Chinese people. If you're Chinese, she has some kind of fear. Ever since she was little, she has had nightmares about Chinese people kidnapping her. And I don't know what it is. I don't know what it is about that. It's just a childhood thing. M. Young says, "Oh, my husband whistles in the car and I feel stabby about it." I'm a good whistler though. I'm very good. Oh, Nick has a fresh haircut. Is he streaming already? Why is he streaming so early? Am I going up against Nick? Damn, the numbers are good in that case. Good numbers, guys. Hit that like button and subscribe. All right. Now I gotta see Nick's haircut. Damn it. Look what you did. Look what you did. You are distracting me by making me go over and look at Racket's haircut because I have been wondering why he let it get so shaggy. Hold, please. We have to go and stream snipe for a second just so we can check out the haircut. He's not live. You're lying. Wait, is he? He's not live. Wrong. False. False alarm. Unless he's just doing a Rumble stream. He's not on YouTube. Damn it. All right, we're getting back to it. Stop trying to distract me. Stop it. Did you see that the Delphi murderer lost like 80 pounds in prison? Same for Alex Murdaugh. Well, the food is terrible. What do you expect? You're not going to eat that shit. My immediate thought was, damn, maybe I need to get on the prison diet. It's funny you should say that. Because if you remember Evita Tolu, my attorney friend in Missouri, when I was doing the Missouri investigations, and I was traveling there and stuff, and I was for sure I was going to get arrested, both she and I were like, well, the upside is if we get thrown in prison, we are for sure going to lose a few pounds, maybe 15. Where is he live, you guys? No, he's not. Oh, he posted a picture to his socials. Well, why don't you be more specific? I just wasted like 3 minutes of everyone's time looking for his hair. All right, never mind. Sorry, Reddit. I'm getting back. Somebody said they attempted the bingo. All right, hold on. Oh, IT goatee for the rescue. Well, that's not a very short haircut. Hold on. How do I share this instead? This is what everyone is freaking out about. He barely got any off the top. I was not expecting this. I was expecting like, the Nazi youth haircut that he usually has. Oh, sorry. Yahtzee youth. It looks the same, except a little shorter on the sides. It looks the same. But Nick always looks good, so it's fine. But you're all freaking out. I thought he got like high and tight. I thought you were telling me that he was gonna, have some kind of like he went back to the Yahtzee youth haircut that we all love so much. Seriously though, that is a funny haircut, and I like it. But he has been getting pretty shaggy recently. I'm glad to see he got it cleaned up. Legal Vice says, "Oh, look, that's rich." Megan concerned that she wasted 3 whole minutes of people's time with rambling. It's not the usual 17, but look, we're at 20 minutes already, and I'm like 3 sentences in, so I'm not doing well. I'm not doing well. Stop talking about hair. I need my dad on a button. I do. I need my dad on a button. Okay. Petitioner obtained new counsel. She did not request an extension of time or otherwise indicate that she would not be prepared for the deposition. Yeah, that's a problem. That's a problem right there. So you you had a month to know when your deposition date was, which is compulsory. It's not optional. You get new counsel, but you don't request an extension, you just don't show up. Oh shit. You're right, Ginger. I forgot all about bingo. The ADD meds have worn off. It is 11 o'clock at night. Where's bingo? Ah, all right, here it is. All right, our new bingo card for the evening. Here it is. Good work. Good work. And I like the red, white, and blue motif tonight. All right. Blue chop, baby bingo. All right, wait a minute. How is this bingo? There are only 9 squares and no free square. All right, we'll just have to deal with it. We'll have to deal with it. Reddit. Warrant failed to appear. No more babies. Uses other uses for your throat. Megan blowjob joke. Oh, it's funny. Okay, Clayton, fellatio. This is good. This is very good. All right. So we already have failed to appear. We can check that off. We have failed to appear. It's tic tac blow. Wait, does that count as a Megan blowjob joke or a chat blowjob joke? I think that counts as chat. So I don't get to black that out yet, right? Oh, you have to fill the whole card. I see how this works. It's not a 3 down or 3 across or 3 diagonal. You have to fill the whole card. Yeah, that's chat's joke. That doesn't get to be my joke. I have to come up with my own blowjob joke. Oh, now the pressure is on. The pressure is on. Damn. Unhung Hero, thanks for the super chat. Says tic tac ho. I love it. It's funny. Good work. Good work, chat. All right, let's go back over to the document. I will keep that open and in mind so that we know what's happening here. All right, window, document. It should also be noted that petitioner, through her prior counsel, filed a motion to quash the deposition filed on January 2nd of 24, which is still pending before the court. Respondent provided his response objection on January 4th of 2020. He means 24. He said 23. That's a typo. Scrivener's error. We'll let it slide. No reply was timely filed, and no court order restricted this properly noticed deposition. Still, petitioner willfully, see attached, failed to attend. Wait, Ashley says, wait, do you have on Christmas jammies or camping PJs? Well, technically it could be both because there are evergreen trees and campers on it. But I think technically it's camping. It's a Walmart special. Thanks for the super chat, McRae. McRae says, Megan has ruined me. I just paused for a bathroom break and had hold music in my head the whole time. It's a thing. You're just going to have to get used to it. Oh, man. I do need my face cream, though. That I need to get before the night is through. No reply was timely filed, and no court order restricted this properly noticed deposition. So, your fault. You snooze, you lose. Still, petitioner willfully, see attached, failed to attend. The reasons provided by petitioner... This new printer is really starting to freak me out. It keeps making noises and making me jump. The reasons provided by petitioner's new counsel for not attending the properly, and he says property, that's also another Scrivener's error. We need to get him somebody to edit this. The properly noticed deposition failed to comport with Rule 57. Arizona Rules of Family Law Procedure. As a result of petitioner's failure to attend and failure to adequately provide notice of her non-attendance, Respondent has incurred attorney's fees and costs, which he is entitled to under Rule 57G. Petitioner's counsel. It's making noises again. Stop it. Petitioner's counsel indicated that he will be filing for some sort of request for protective order. As petitioner's most recent counsel was advised in the correspondence attached, this is not valid cause to fail to attend a deposition and does not comply with the rules. The communications regarding the deposition are attached heretofore as Exhibit A. The court currently has a motion for sanctions pending. Respondent intends to reference this notice in advancing the consistent arguments, consistent is underlined, regarding appropriate consequences for the petitioner's continued noncompliance with the rules, including legal fees and other relief available per law. Respectfully submitted, Greg Woodnick. All right, now we are going to go to the bottom of these exhibits, and we are going to read the emails in their order because this is the real tea. This is the real tea. And this is from Isabel Sissel to, so this is from her new lawyers, the Valley Law Group, to Greg Woodnick, copying Corey Keith, who is her new attorney. And by the way, these emails are not redacted. Don't send these people emails. I told you not to do that, so don't. In regard to, although their emails are public, it's not like it would be a problem, but don't do it. Good afternoon. In regard to the above referenced matter, please send the attached notice of appearance that has been filed on behalf of petitioner Ms. Owens. A physical copy will not follow unless otherwise requested. Okay. So let's go see what that notice is. From Corey Keith to Woodnick Law. Dear Mr. Woodnick, I intend to depose Mr. Eckert at my office. Please let me know yours and your client's availability on the following dates: February 1, February 2, February 8th. Oh, so you want to depose Mr. Eckert, eh? And you would expect him to show up, wouldn't you? I bet you would, Corey. I bet you would expect him to show up. From Greg Woodnick to Corey Keith. Corey, I'm a bit confused, as we were contacted by a different firm indicating they would be taking over as a representation of Laura. Under normal circumstances, I would have brushed that off as maybe wires being crossed, but I think you will be the 12th or 13th lawyer in this melee. Damn. I need my damn button. Shit. I still haven't set it up. Brad, you really need to tell me to do these things quicker than I have. Where's my voice mod thing? Where is it? Hold on. I need my other sound effects that aren't on the board. I really need to add some of these to the board. That's not it. Where's voice mod? No. There it is. Open Sesame. Why isn't it open? This is bizarre. This is bizarre and weird. All right. I don't have the buttons I want. Damn it. All right, moving back over to the document. You must be the 12th or 13th lawyer in this melee, so I want to make sure that you're not already withdrawing. It has been a pattern here. I haven't even read some of these. It's so funny. Brad, I can't find voice mod. It usually opens on, like, when I do the, when I open my computer, it's like there. Today, it's just not there. Where is it? I mean, it's working because you guys can hear the buttons, right? So why isn't it here? It's bizarre. Voice mod. Open. We'll try that. Open. Open, please. Open says me. Ah, there it is. Okay, hold on. Soundboard. Aha! That's what I was looking for. Now it's there. For the love of God, move on. Ashley Casey, I can be more properly motivated when super chats come in to make me move on. I am I can stay more on topic if the super chats are flowing. Um, just a suggestion, but it's not a requirement. I understand that most of us here are medium poor, and I love you just the same. Okay, where are we? Regardless, I am just happy that Laura has counsel. Can you imagine if she did this pro se? That would be so funny. Oh yeah, I'm supposed to be quiet. This is the chill stream. Welcome to ASMR. Chill stream. As it will keep our deposition on Wednesday productive. Do we need some background music to this? As it will keep our deposition on Wednesday productive, as a reminder, Laura is remiss in her discovery obligations. To date, she has provided none. Zero. As a reminder, per Rule 62, she needs to bring the requested documents to the deposition, attached as Exhibit A along with the notice. I'm also happy to resend blank HIPAA releases. They were ignored previously for her to execute. What do you mean the buttons were a bad idea? Rachel K., I reject that. The buttons are a fantastic idea. I love them.
You are fake news.
That's right. St. Dodo, thanks for the super chat. I appreciate that. Or super sticker. I guess that's a super sticker. I'm going to turn the music off. Don't worry. I know it was too loud. All right. As to your date request to depose Clayton, of course we can make that work. And yes, we are available on Groundhog Day. Because they have been doing this over and over and over and over again. It's apropos, really, that it be on Groundhog Day. Let me check the bingo real quick to make sure I haven't missed anything. Clayton, we hit Clayton. We can X off Clayton. Okay. Aha. McCrae, thanks for the super chat. Says Squirrel, see locals chat for questions asked about ADD. Well, if I do that, I'm gonna get in trouble. IT Goatee, moving on. Thank you, Brad. Sorry. I need to apologize for me. I need to apologize for myself. Oh no. Hold on, I'm sorry. But Locals is making memes of me not being able to stay on topic, and it's really funny. Wait, I have to read what it actually says. I can't see what it says. Dang it. Now I've screwed something up. Wait, I lost Locals. How did that even happen? Damn it. There it is. Wait, why can't I get up to the top? Start stream talking about fellatio impregnator case. Sorry, everybody, Mr. Fox is printing. Oh, Locals, we need a bingo card. I need to show you what Reddit enjoys most about this channel. Where are my buttons? Brad! Several days later. Chat, you lied to me. Nick didn't get his normal Yahtzee youth haircut. He barely trimmed the hair of the dog. Oh my God, Reddit is going to hate this so much. I have to stop talking about it because they are going to hate this. I know it's bad, but I was making dog food and drinking wine, and the meds have worn off. Like, there's no excuse for me. I don't know what to say. This is me. These are the ABCs of me, baby. It's just what you have to put up with, I guess. I'm trying hard, though. This is what it's like to have learning disabilities. For the I do not take Adderall. The side effects of that are terrible. For the Adderall refill fund, thank you. It's Vyvanse. Vyvanse works way better. It has way less to no side effects for me anyway. St. Dodo says Reddit cat gang the flock. Yeah. XOXO. The flock are the Redditors that are doing all the great work, but they hate me a lot. I like them, so I'm not sure. I'm not sure why we have such a disagreement. Okay. Sorry. Back to the document. Also, Groundhog Day. I'm just glad to hear that Laura agrees, underlined, that further discovery is critical. So we welcome the formal notice, please dispatch, for the record. I am requesting that we start a bit earlier, 8 a.m., at your office, because it is on a Friday and I have other commitments in the afternoon. Isabel, copied, will be there with me, as in light of your client's history, we don't engage with her without witnesses. Wow. Yeah, I wouldn't. I mean, that's the way you have to deal with these types of people. You got to have witnesses because you don't want there to be allegations, shall we say, because there could be allegations coming from this one. She's terrifying. I love that. I love that last line, though. That's good. We don't engage with her without witnesses. I would suggest nobody engage with her without witnesses. Okay. Signed, happy to talk offline today if you have a few minutes. Signed, Greg with 2 G's. I'm very confused about that Greg with 2 G's, by the way. Is it Gregory with 2 G's or just Greg with 2 G's? I mean, the 2 G's is like, bam, 2 G's. I've never seen Gregory spelled with 2 G's. I'm going to ask him that if I ever get to interview him. All right, let's go up. That was Monday, by the way, January 15th. And this is Tuesday, January 16th, from Greg to Corey. Corey, as a professional courtesy, I wanted to let you know, as I'm sure Laura is expecting, there may be a police presence at my office tomorrow for the deposition. Yeah, you're going to need that. I'm also attaching the vital records form for a fetal death certificate. Please encourage Laura to populate and bring to the deposition. My staff can notarize it for her here. She also needs to bring her Rule 49 and Exhibit A per Rule 62. The depo videographer is not inexpensive, and we just confirmed with John. Laura needs to be here at 1 p.m. for a prompt start. I do anticipate needing most of the 4 hours. We look forward to meeting you both in person tomorrow. Holy crap. You know, Archangel, it's hilarious you say this. Who needs TV when you're married to Megan? When my father gave a speech at my wedding, he was so funny. He goes, my wife and I, our TV broke in 1978. I was born in 76. He goes, our TV broke somewhere around 1978, and we never replaced it because there was no need. Megan has been entertaining us from the very beginning. So it's funny you should say that because my dad agrees. My dad agrees. Dang. What did I miss over here? Oh. Agnev. Thank you for the super chat. Appreciate the super sticker. Okay. Man, that fetal death certificate, that is the death knell for this whole story. All right, so... Oh, wait, let me check the bingo. I think we have another one. No more babies. Yep. Because he's asking for a fetal death certificate, so we'll check off no more babies. All right, let's see. And then same day, Tuesday, from Corey Keith, January 16th. Mr. Woodnick, thank you for your email. After reviewing this case more thoroughly, I'm writing to request your position on both parties signing a protective order under Rule 53 with relation to the deposition. They want to seal it. They want it so that we cannot see it. Specifically, we will be requesting that the deposition transcript testimony and any supporting video is documented as highly confidential and kept under seal. We will also request that the deposition scope is limited to matters relevant to this proceeding, assuming your client does not intend to annoy, embarrass, oppress, harass, or leak the information. I am hopeful that they would be able to sign this agreement for same and move forward with the deposition tomorrow. Please let me know your client's position as soon as possible. If we are unable to reach an agreement, I will be seeking court intervention prior to my client being present for any deposition. This is the greatest response, you guys. So this is from Greg Woodnick, same day, Tuesday, January 16th. Corey, number one, Clayton will not be agreeing to a protective order. No, he will not. No, absolutely not. Or filing this case under seal. Your client went to The Sun, People Magazine, TMZ, Reddit, Medium, etc., and continues to post and contact the media to date. Also, it is highly doubtful that you will be able to meet the high burden to have a case sealed. Note, your client already tried this and was denied relief.
Denied. Sit down.
Yeah, there is a high burden. We're going to look that up, actually. I need to find that. Let's see. Burden to seal a court case, Arizona. Sealing records. Yep. We're going to look that up because there is a high burden, and I want to actually talk about what that is. Let's see. No, I don't like that one. We'll look it up later, but I will look it up because I want to know what the burden in Arizona is. It's different in every state. It looks like... there's the code. Got it. I have the code. Sealing of arrest, conviction, sentencing records, requirements, fee, appeal, no, we want to know about sealing of court cases. That's different than arrest records. All right, I'll have to do more research on that, but I promise that I will find that. Nick likes the soup. If you're in the locals chat, you could probably find that faster than me because you're like a lawyer and stuff. So that would be fun. If you're here. I don't even know if he's here. Is Nick here tonight? Yes, he is. So Nick, if you have that, if you can find that for me, like what's the burden for sealing a case in Arizona? I would love to know that because I think it is very high. I think he's right. Number 2, as you are aware from the pleadings, we will absolutely be addressing the malignancy of her allegations, including her historic prior allegations, as they are directly relevant to her bad faith motivation to file this matter. Note, your client also repeatedly refers to her prior pregnancies in sarcastic quotation marks in her emails and text messages to Clayton, which we disclosed. Moreover, her prior allegations are entirely relevant to our motion for sanctions, and she has a history of fabrications, and her playbook in this underlying matter is almost identical. Some texts read like they are cut and paste. Yeah, word, they do. They do. Cut and paste, man. From the Gillespie matter, we appreciate that subject matter of fabricating pregnancies is embarrassing, but her responses to the questions are absolutely relevant to the pending action in court. Yeah, they are. And there's just seriously no other, there's nothing else she can do other than respond to this and tell the court one way or the other whether she was pregnant or not. Like it has to happen. It has to. Number 3. I mean, how dare she complain about being embarrassed? She brought this on herself. She literally went to the media herself. You cannot go to the media yourself and be like, "Oh, I was so wronged and I did this and this is what happened to me and he did this to me." And then it turns out that it's all a load of shit. And now you want your privacy? Now you're screaming on a street corner?
We want privacy! We want privacy!
Yeah, no, that's not the way it works. That's just not the way it works. Number 3, your objections at deposition are obviously limited by law. If Laura attempts to terminate deposition because we are asking questions that are directly related to her sanctionable actions, that is obviously your choice. I am fairly confident that Judge Mata is not going to agree with you, and she will be exposed to consequences, including attorney's fees and paying for the reporter costs for yet another deposition, so that the discovery process can be completed. I have zero intention of asking questions that do not serve a legitimate purpose. Much of our time is going to be spent confirming foundation issues because your client, after she claimed she was no longer pregnant, insisted on exercising Rule 2. Oh, I got to go back to the bingo card. No, we already got no more babies. Okay, got that. Number 5, last, no matter what questions we ask, your client will claim they are meant to harass. I assure you that is not the case. Number 6, I trust Laura told you that she had the opportunity to avoid this by acknowledging that she was never pregnant by Clayton. That offer still stands. Do it. Do it. Last, this deposition was properly set 3 weeks ago, and I have spoken to 2 other lawyers for Laura in that window. If Laura is now refusing to participate without her demands being met, it is not only an unreasonable request based on the history here and her publications, but a late one. You are more than welcome to call me to discuss. I appreciate you are in a difficult situation, having taken this case in this posture. Dang, Greg. That was savage. And I loved it.
You will pay for what you've done. And I pray that God send angels to visit vengeance upon you.
Yep. All right, let's see. All right, the same day, on Tuesday, Corey Keith responded to Greg Woodnick and said, Greg, I appreciate your understanding of the interesting situation I walked into in this case. This is lawyer speak for this is a shit show, and I didn't know how much of a shit show it was until I walked into this case. This poor dude. Seriously, this poor guy. I know you and I are in opposition on this one, but I hope we can represent our clients with the understanding that we are both simply representing our clients and not take issue with each other for doing so. Let's hope our next case together isn't so contentious. I believe, and maybe I'm wrong, and maybe Jeff, if you're in the chat, can tell me if I'm right. To me, this is lawyer speak for, I know I've got a dodo bird on my hands here, but I have a job to do, and I hope that you won't hold it against me, that I have to do this really stupid shit that my client wants me to do. And I'm sorry, and I hope you won't think that I'm a bad lawyer because of it. After speaking with my client, and if I could read between the lines and not being able to convince her to come clean, Jeff says, you are right. 2 good lawyers, one of whom regrets his situation. Oh, I told you, Corey, that you were gonna regret this. I'm so sorry this is happening to you, Corey. Whatever you do, have witnesses when you're alone with this woman, or you might be the next father facing paternity claims. Whew. After speaking to my client, we will be filing a motion for a protective order relating to both parties' depositions of each other. So he wasn't able to talk her out of it. I will have this filed by the time of the deposition tomorrow. My client will be awaiting further order from the court with relation to this before subjecting herself to Mr. Eckerd's deposition of her, and she will not be present for deposition tomorrow. To be clear, this is not my client saying she does not want to be deposed. I believe her motion to quash adequately stated and put Mr. Eckerd on notice of this, but instead that the deposition should be confidential to avoid continued embarrassment and annoyance as she has undergone this thus far in and outside of these proceedings. Well, ma'am, if you didn't want to be annoyed or harassed and harassed is not the right word, annoyed or embarrassed, you should not have gone to the media. We would never have known about any of this if you did not go to the media. There is no way in hell Clayton Eckerd would have gone to the media about this unless he was exonerated or something. But you, ma'am, you went there. You went to the Sun. You went to TMZ. You went to Page 6. And because we now have found that your claims lack credibility, they lack even a scintilla of a hint of credibility, you cannot now say that you are embarrassed because of the public scrutiny that you asked for. Ma'am, you asked for this. I'm shocked by her hubris that she thinks she can do this and get away with it. My God. I mean, am I wrong here? But I just feel like ringing the shame bell. Shame on you, ma'am. Shame on you.
Shame.
You don't get to do this. You don't get to make allegations in public and go to the media. You just don't get to do this.
Shame.
And then say,
Shame.
I need it all sealed
Shame.
because I'm suffering embarrassment. You're suffering the embarrassment. Welcome to the consequences of your own actions, ma'am. I mean, my God. This is so crazy. All right. So he says, in order to allow the court to weigh in on this deposition and request for confidentiality appropriately, Ms. Owens must seek this leave prior to the deposition. Wednesday, January 17th, which is the day of the deposition. Oh, what time was that sent, by the way? So that was sent the night before, evening before, 4:08 p.m., late afternoon. So on a Wednesday morning, 10:54 a.m., Greg responds and he says, Corey, I appreciate you letting us know that Laura is not planning on showing up to the noticed deposition this afternoon. That said, and as I am sure you advised her in a CYA letter, is that a cover your ass letter or does that mean something else? Jeff, what does CYA mean? Is a CYA letter some legal term I don't know of, or does that stand for cover your ass? And as I'm sure you advised her in a CYA letter, she is not allowed to simply ignore a properly noticed deposition. Dang. In light of her actions and exercising efforts to save Clayton costs, we are canceling the court reporter. We will include the anticipated cancellation fees required by the service in our cost statement and append it to the anticipated China Doll affidavit note. We will prepare an affidavit confirming. Are you serious, Legal Vices? It really means cover your ass? Oh, dang. Dang, Greg Woodnick. You get it. This is the mood that Greg's in.
You will pay for what you've done. And I pray that God send angels to visit vengeance upon you.
Dang. That's funny. Jeff, have you ever seen Cover Your Ass CYA written in a in legal emails. Jeff says, yeah, her lawyer should let her know in writing that she can't avoid it. So she can't say he told me I didn't have to go. She's totally going to say that anyway, though, because she's living in another reality. Note, we will prepare an affidavit confirming her non-appearance and send you the same after 1 p.m. The matter has been set for trial. Laura needs to comply with Rule 49. She has provided zero disclosure, notwithstanding you being the third attorney I've communicated with about this family court case. All right. I am sending you again oh my God, the second time, the fetal death certificate form I provided to you yesterday, and submitting for the third time the HIPAA forms attached for each of the following providers: Dr. Zeman, Tamara Lister, Dr. McCool, Dr. Higley, and PPC, so we can get the records directly from the source and consistent with her testimony in court already. As explained to Lexi before she quit the case, we will not accept any records from your client that are not given to us from the providers directly. There is an arts and crafts history here. Fortunately, Laura herself invoked Rule 2, so she should be more than cooperative with signing releases so we can get the records from the source. I am disappointed, but certainly not surprised that the deposition is not proceeding today. Dang. I got a couple of super chats here that I didn't get to. Laura Bronson, thanks for the $20 super chat, says, oh my God, on with it, woman. I am sorry. I am deeply apologetic. Enchiladas Unbreaded, I haven't seen you in forever. How are you? Thank you for being here. Thank you for the super chat. Says, I hope you have a safe trip. Prayers for your friend and her family. Thank you so much. Ma Rini was a great lady, and I enjoyed being in her kitchen on many occasions. And I was at every holiday in her big Italian loud family with all the delicious food. And she just loved us so much. She was our biggest fan. She laughed at everything her daughter and I got up to, every nonsense that we got up to. She was always so positive, so cheerful, so kind, always with her Italian bakery cookies. Every time we would go over there, we would sit down at the kitchen table and she would have coffee and there would be something from some Italian bakery there. And it was wonderful. And I loved her. I love her still. She's an amazing spirit, that woman. And I love her. I'm going to miss her. Where am I at? From the source. Yes. Okay. So we're going up to the next one. Is that it? Is that all the exhibits? Okay. Those are all the exhibits in that one. So we got through. Those are pretty amazing, aren't they? Like, those are some good emails. Those are fantastic. All right, hold on. Oh yeah, Italian mamas, man. There's always something good on the stove. You will never go hungry in that house. There's bakery products, something cooking delicious somewhere. Yeah. It was epic. I used to love going there. And on Christmas Eve, they always had seafood, which was something that I was not used to because my family was not Italian, but Italians do Christmas Eve with seafood. And it was incredible. There would be like platters of shrimp and, just beautiful, beautiful food. Always beautiful food at that place. She also used to have, so her daughter and I, my best friend, we were in theater together, and she would collect our tapes of our shows and watch them like movies. So sweet. So sweet. I remember going over there years later after we were not in high school anymore. And she was like, guess what I have? I've got Into the Woods or whatever it was. No, that wasn't it. What was the show we were in? There was this one musical that we did, and she had a VHS tape, and not even my own mother had that tape. I don't even know where she got it, but she would she would watch it, just for fun because she was our biggest fan. So sweet she was. Why is my page reading itself alive to me? Aloud, not alive, aloud. That was weird. Okay, I have another one that I need to get to. Where's the other one? I have to open my email. Hold, please. This next one, it's some kind of crazy. It is her response, Laura Owen's response to not showing up for her deposition or something, or for wanting it to be sealed. I don't know. It's hilarious. Motion for sealing. Motion for sealing it. Ma'am, it is too late to seal this court case. It is too late. I don't know who redacted this, but the redaction is really ineffective. It wasn't me, and these things don't really need to be redacted because all of the emails on here are public for attorneys and stuff. They're on their websites, so I'm not going to worry about it. All right. Window. To the window. To the wall. All right. Motion for confidentiality and preliminary protective order. If you are going to redact a document, use a darker Sharpie is all I want to say. Petitioner Laura Owens. Hereinafter petitioner, by and through undersigned counsel, hereby files this motion for confidentiality and preliminary protective order pursuant to Rule 53, Arizona Rules of Family Law Procedure. Petitioner requests the court sign and adopt. Oh, before I forget that, I need to look that up because I bet that's where the burden is. Hold on. Rule 53, Arizona Rules of Family Law Procedure. Okay. Oh, I should have checked locals because Nick may have found it for me. Dang, 31 new messages. Shit. All right, hold on, Nick. I see you're trying to get my attention. What do you have? More memes. Hold on. Hold, please. I have to catch up on locals. Aha! Case text. Rules of civil procedure. Nice. Thank you, Nick. All right. Actually, let's read this. Let's read through this a little bit before we get over to this document, because I think it's important to know the context. Like, is this possible for her to do this? Like, can she ask for, under the rules, for this case to be sealed? I don't think she can. Let's look what it is. Sealing and unsealing court records. A, generally, unless authorized by statute, rule, or court order, no document may be filed under seal in an unsealed civil action. Definitions. For this rule's purpose, document means any filing, exhibit, or record. Yeah, we get it. Case initiating, we understand what public access. Public access means the inspection or copying of a document by a member of the public, and sealed document means a document filed or lodged with the court for which public access is prohibited by statute, rule, or court order. Order permitting a document to be filed under seal. Generally, on motion, stipulation, or on its own, a court may order a document to be filed under seal if this rule's requirements are met. Unless the court determines that an entire category or type of document meets this rule's requirements, a court may not enter an order that gives advanced authorization to file such documents under seal. Okay. So you have to meet the rules. You can't just seal stuff willy-nilly. There can't be willy-nilly sealing of things. Requirements. Unless a statute, rule, or prior court order authorizes a document to be filed under seal, a court may order that a document may be filed under seal only if it finds in a written order that A, an overriding interest exists that supports filing the document under seal and overcomes the right of public access to it. Well, I wonder what the overriding interest would be. That's what I want to know. What's the overriding interest? B, a substantial probability exists that the person seeking to file the document under seal or another person would be prejudiced if it is not filed under seal. Yeah, again, I'm going to need the definitions of how that would be, how the person would be prejudiced. Okay, hold a minute. My feet are cold and I brought socks for this very, very occasion. So one moment. I have to put my socks on. Yes, Brad, I'm keeping my toes away from the power button. I'm trying. I'm going to put my socks on and my slippers. My slippers. You're not. I knew you were going to say that. I knew you were going to say that before you even said it. You can read me. You read me so well. You know me so well, Brad. All right. Toes situation remedied. The temperature is dropping. I'm going to put my robe back on. Wait. Hold, please. Carefully crossing legs so as to not hit the power button with my foot. All right. Letter C. The proposed restriction on public access to the document is no greater than necessary to preserve the confidentiality of the information subject to the overriding interest, and D, no reasonable, less restrictive alternative exists to prove the confidentiality of the information subject to the overriding interest. Yeah, but I need to know what the overriding interest might be. Is there a definition of that? I hope to God there is. Orders contents. If all of a document is protected, if the court finds that the requirements for filing a document under seal are met and the entire document meets those requirements, it must order the clerk to file the document under seal. Okay. If only part of a document is protected or certain pages or portions, blah, 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 it must order the submitting person, if he or she has not already done so, to file a publicly accessible version of the document that redacts only those portions of the document, and the clerk to file under seal the unredacted version. Okay. Okay, but this is all about if they do. Clerk's duties, don't care. Record on appeal, don't care. Denial of motion or stipulation to seal. Denial, don't care. Sanctions. A court may issue monetary sanctions against any person who discloses any document or any protected portion of a document the person knows or should know it is sealed or lodged under this rule. A court may also issue monetary... Yeah, but doing that across state lines is really difficult because an Arizona court really doesn't have jurisdiction over somebody across state lines. I know this because I've done it before. I'm not saying I would do it or break a court order to do it. I'm just saying that I have done it in cases where it has been extremely inappropriate for court documents to be sealed and judges were just covering up their bad behavior. And under that type of situation, I would publish it because judges acting unlawfully should be exposed. Not saying that that would be the case in this case, but I have seen it happen before. Motion or stipulation to file a document under seal. I want to know what the overriding interests are, and I'm not seeing that. I'm seeing... How come it doesn't define those? Hold on. Nick, do you see where it defines the overriding interests? That's what I really want to know. What are the overriding interests? I'm checking locals to see if you have an answer. All right, going back over here. I don't care about clerk's duties, procedure of request. No, don't care about that. Documents produced by others that are governed by a protective order or confidentiality. No, that doesn't apply. Yeah, nothing in here talks about what are the overriding interests, and that's what I want to know. All right, getting back over to the document, to her motion to seal, which is crazy. All right. Statement of facts. Facts. We're not doing so well on bingo tonight. We still haven't come across twins, Reddit, warrant, fellatio, Megan blowjob joke. That's on me. I still haven't come up with one. It's too much pressure. Other uses for your throat. We're still behind. Statement of facts. Number 1, on August 1, 2023, petitioner filed her petition to establish paternity, legal decision-making, parenting time, and child support hereinafter the petition. Jeff, you missed nothing. It was just me trying to find the overriding interests in the code. Just me trying and failing to find what are the overriding interests that could seal this case, and I couldn't find it. We got the code, but the burden, I'm still not clear on. In fact, I'll send you the case text, Jeff. Maybe you can find it. I'll send you the case text on Twitter. But what I'm looking for would be the definition of the overriding interests and what is the burden of proof. And I'm not seeing that. You know, the burden of proof to seal something. Oh, Jeff, thank you for sending me this, by the way. Hold on. Reddit. We can cross off our Reddit square now because we now have something from Reddit. What does TBF mean? To be fair? Is that what it means? To be fair? Hold on, I need my Reddit
voice. TBF, I watched a live with Megan in it and was appalled at what the co-hosts were saying. They couldn't form a coherent argument if they tried. I respect her as a journalist, but I think if I was her, I would be cautious of who I associate with. Last night I tuned in only because I wanted to see what she was saying and left feeling like, wow, I can now see why some people were concerned about her. We can't control who covers it, but we can discuss how they cover it. I am thankful for what she's done for Liz and hope in the future that Megan and Legal Vices choose people to have on as guests with more education, credibility, and can actually engage in meaningful discussion. Last night wasn't it.
That's you? Saint Dodo, that's you? You didn't like Nina? I guess you didn't like Nina then, is what you're saying? You didn't like Nina and Chandler? Sorry. I mean, let me apologize. Let me offer you my deepest condolences for your upset. What are you so upset about? Because, well, Nina hadn't heard about it yet. She didn't know anything about the case. So I was just kind of, filling her in. And I don't know what upset you by that conversation, but I thought it was a good one. Jojo says awkward. I'm glad you're not triggered. I'm not triggered either. Your opinion is welcome here. By the way, we would have bingo if this were an actual bingo card because we got to hit the Reddit square. Look, see? But because we have so few squares, we're trying to hit all of them. So we still have twins, fellatio, Megan blowjob joke, other uses for your throat, and warrant.
That's what she said.
Okay. Back to the document. Hold, please. All right, here we go. On August 21st, 2023, respondent filed his response to the petition. On December 28th, 2023, petitioner, I like this timeline, by the way, because it lets you see how much shit Clayton has been through. On December 28th, 2023, petitioner filed a motion to dismiss, requesting that the court dismiss the petition. Number 4, on January 4th, 2024, respondent issued a notice of deposition summoning her to attend a deposition scheduled for January 17th, 2024. On January 11th, 2024, undersigned counsel filed his notice of appearance on behalf of petitioner. On January 16, undersigned counsel emailed legal counsel representing respondent, opposing counsel, asking if respondent would agree to a preliminary protective order with relation to the deposition. Respondent declined. Oh, I've got a good sound effect for that. Dang. Ah. McNutt, that is not true. Chandler is a paralegal. That's how she tells people she's a paralegal. That's the work that she's done. She's a paralegal. She's never told anyone she's a lawyer. She's not posing as a lawyer. She's acting as a paralegal and giving her legal opinions based on her work as a paralegal. So Chandler's a good girl. Calm down. And she's in the beginning of her career. So, give her a break. Chandler's much younger than me. And I've had a lot more many more years in this field, even though I'm not a lawyer. No, St. Dodo, she was not implying she went to law school. She takes legal courses with Andrew Branca, which is not law school. If you knew about Andrew's school, it's not law school. It's legal courses. And she has never said she's a lawyer. No. I like Chandler a lot, so we'll just leave it there because I do. I think she's sweet and she's young, and give her a chance. All right, let's see. Following the referenced January 16th, 2024 email exchange, undersigned duly notified opposing counsel of his intent to submit this motion. It was also conveyed that petitioner would seek the court's issuance of a protective order prior to her deposition. Number 2, law and argument. Rule 53A, ARFLP, allows the court for good cause to enter an order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense, including one or more of the following. But let me ask this question. Can you protect a person from annoyance, embarrassment, and oppression that she caused on her, to herself? Did she? Didn't she do this to herself? You can't protect her from herself. Literally not at all. Yeah, Andrew Branca has a school, by the way. Mazda's pointing it out. He has a school, by the way, where you can sign up to take legal courses. It is not a law school, but it teaches you about law. And I forget the name of the website, but if you just look up Andrew Branca, you'll find it. And yeah, she has taken law classes, and they're from Andrew Branca's school. He basically teaches people stuff about the law. All right. Moving on. Law and argument. Okay, so we got this part, including one or more of the following: forbidding the discovery, specifying terms and conditions, including time and place for the discovery, prescribing a discovery method other than the one selected by the party seeking discovery, forbidding inquiry into certain matters or limiting the scope of discovery to certain matters, designating the persons who may be present while the discovery is conducted. Requiring that a deposition be sealed and opened only on court order. 7, requiring that a trade secret or other confidential research, development, or commercial information not be revealed or be revealed only in a specified way, and requiring that the parties simultaneously file specified documents or information in sealed envelopes to be opened as the court directs. Furthermore, Rule 53D also allows the court to enter an order that limits a party from disclosing information or materials produced in the action to a person who is not a party to the action. They are desperate for her. She is desperate not for us to not have the evidence that she was never pregnant. Yeah. I cannot believe the chat is so obsessed with Chandler and her legal education. She is a paralegal. She has done all the classes that she needs to do to get her paralegal certification or whatever it is. And she has also taken classes from Branca, which is not certified. Like, that's not like a certified bunch of classes like to get any law degree, but it's just for your own education. So everybody calm down. Chandler Remington is great. Well, St. Dodo, if many states don't have regulation for paralegals, that doesn't mean that her state doesn't. Focus, chat. We are trying to get through this. Stop it. The chat needs ADD meds right now. Everybody calm down. Yeah, I'm going to have to tell Chandler she's on her way to being incredibly popular because the chat cannot stop talking about her. That is a very good sign for Chandler Remington. Mimi, thanks for the super chat, says, for another medium smart hold, please. Get him. Well, just because you sent the money, hold, please. All right. Furthermore, Rule 53D also allows the court to enter an order that limits a party from disclosing information or materials produced in the action to a person who is not a party to the action. A party seeking confidentiality must show why a confidentiality order should be entered or continued. So that means Owens is the one who needs to show why this confidentiality order should be entered. B, the party opposing confidentiality must show why confidentiality order should be denied in whole or in part, modified or vacated. And I think Greg Woodnick did a good job of that. We read that the other day on the stream. The burden of showing good cause for an order remains with the party seeking confidentiality. Additionally, Rule 53(2) requires that the court make findings of fact concerning any relevant factors, including but not limited to any parties or persons need to maintain the confidentiality of such information or materials. Any non-parties or interveners need to obtain access to such information or materials, and C, any possible risk to public health, safety, or financial welfare that such information or materials may relate to or reveal. Okay, let's think about this for a second. And let's look at A. Any parties or persons need to maintain the confidentiality of such information or materials. Well, the reason why Ms. Owens wants to maintain confidentiality of the information is so that she is not exposed as a liar to the public. However, she went to the public claiming one thing that she is now saying what? Didn't happen, isn't true anymore. There are 666 of you right now. I don't like that at all. Somebody needs to share the stream so that there are 667. That's a bad sign. Have all of 666 of you hit the like button and subscribed? Because at least then I wouldn't feel like this was like, I don't know, some kind of demonic stream. Oh, there we go. 673. Great. We have now left the 666. Excellent. All right. So we know why she wants to maintain confidentiality. Let's look at letter B. Any non-parties or interveners need to obtain access to such information or materials. Well, that a non-party or an intervener could be seen as being the media. The media is always an intervener in these matters. And we're getting to the point now where the media is going to intervene at some point. It's possible. I mean, if they try to seal this, I can see that happening. I could see the Sun intervening. I could see People magazine intervening to say, no, judge, the public's right to know, because she came to the media and she told us a story, and we have a right to know if that story was true or not, that would override her interest to maintain confidentiality. You don't get confidentiality to maintain a lie. No, absolutely not. C, any possible risk to public health, safety, or financial welfare. Well, that's irrelevant. There's no public health or safety or financial welfare issue at hand. So we're really just talking about A and B. And I think that I've already explained why A does not override B. Case law directly citing Rule 53 is sparse. However, as the commentary for Rule 53 states, Rule 53 is based on Rule 26C of the Arizona Rules of Civil Procedure, which provides additional insight in case law on the subject. Rule 26C1 similarly provides, I think he meant similarly, but he wrote similarity, provides that upon good cause shown, court may make various protective orders that justice requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Yeah, but not if you brought it on yourself. I'm sorry, but there's no way that she gets this when she brought it on herself. The text of Rule 53 provides the court with no fewer than 8 separate and non-inclusive means by which it might ensure that a party is not subjected to annoyance, embarrassment, oppression, and undue burden or expense. In other words, the rule provides the court with broad discretion in fashioning orders for parties or information entitled to protection. Petitioner's proposed protective order, attached hereto and incorporated by reference, requests that relevant discoverable information with which either party designates as confidential remains confidential and is not disseminated to anyone other than the parties and their respective counsel, including if one party objects to the confidentiality designation, and until said designation is removed by the court. But I think what you're going to have in this case is one side is going to say, we don't want any protective order on anything. And the other side is saying, we want to protect everything. And this is not okay. Like, I don't see how this works. Like, if Clayton's like, I don't care, I would give all my medical records to the public. She can't come at me and say, I'm the father of these said twins, alleged twins, and then get to seal all the evidence that shows whether or not that's true. There's no way that this can happen. There's no, if the judge were to rule in her favor on this, it would be the dumbest judge in the world. Is there a dumb judge square on the bingo card? Damn it. No. We want privacy.
How dare you, sir? My Instagram-loving wife has always wanted her privacy.
Oh, isn't it funny that Reddit is so upset about my Meghan Markle jokes? They really don't like the Meghan Markle jokes. And I think, how is it that you can be so ignorant of, like, even South Park? Like, come on. When South Park is making fun of you, like, it's pretty certain that you're a laughing stock. Like, I'm telling the easy jokes. I can't believe these people are out there defending Meghan Markle on Reddit. Is that really happening? And Amber Heard. Can you believe these people on the Justice for Clayton page on Reddit? They really like Amber Heard. Dang. Dang. You know what? Damn it. Divance Moore. You know, you're making the jokes I could have made, and then I could have checked off that square. She should just keep her mouth shut, but then that's how this whole thing got started.
That's what she said.
Phrasing?
Damn it. Still can't check that square off because I haven't made a good joke yet. Shit. Reddit is a psychological disorder. They should put it in the DSM-5. Reddit syndrome. Oh. All right. Petitioner's proposed protective order, attached here to and incorporated by reference, requests that relevant. Wait, did I read this already? Yeah, I did. Let's go down to number 1. Respondents' requested and anticipated discovery will further annoy, embarrass, and oppress petitioner. Well, that's too bad. She shouldn't have filed this bullshit petition in the first place. It's so ridiculous that she has filed this in the first place. She shouldn't have done that. If she hadn't done that, she would not be annoyed, embarrassed, or oppressed in any way. Dang. Respondents' anticipated discovery is sensitive in nature and should be protected. Oh, come on now.
Bullshit.
She's the one who went to the media and talked about all her sensitive issues. Respondent intends to depose petitioner or is seeking discovery related to several sensitive and potentially privileged topics,
Wrong.
including her previous sexual relations.
You are fake news.
Specifics regarding the sexual encounter with respondent,
Quiet.
previous pregnancies,
Nobody cares.
discussions surrounding potential adoption or abortions, her privileged medical records,
Wrong.
her miscarriage. I'm sorry, but none of this stuff is privileged when you went to the media yourself and talked about it. You talked about it. You don't get to say now it's privileged. You went to the press. You gave up your so-called protected HIPAA information. You don't now get to claim that, oh, it's so private and personal. We're so private. We need our privacy now.
We want privacy! We want privacy!
While petitioner concedes, this is funny, that certain discovery may be necessary in this matter to appropriately litigate unresolved issues, including the issue of attorney's fees. This limited issue does not warrant the dissemination of sensitive information to non-parties in this case. Well, Laura, it does. It does, though, because you went to the media in the first place and you opened this Pandora's box. And there was a reason why Pandora was told not to open the box. Don't open the box. If you open the box, you can't control what comes out. And you did that. You did that. And now saying, I want to put everything back in the box, that's just not how it works. And I'm sorry for that, but maybe this is the lesson that Laura Owens needed to learn. McNutt, this is a very good question. You win. You win. How are non-existent medical records sensitive? You win. You win. There are no records, Laura. There are no records. So you cannot say that these are protected somehow. Damn it, chat. You're taking my jokes again. Jokes I should have seen. Jokes I should have seen. What's in the box? What's in the box? Damn it. I still can't get credit for that joke. Shit. Petitioner has already been annoyed, embarrassed, and oppressed by respondents' actions? Are you sure about that? Are you sure that it's the respondents' actions that made you annoyed, embarrassed, and oppressed? Oh, no, no, no. No, Jane Doe. Those are your actions that embarrassed you and oppressed you and annoyed you, not respondents, and has concerns that this will only worsen as discovery continues. Well, yeah, it's going to get worse because we're going to just rip the Band-Aid off. Rip it off. Just rip it off and say, I made a mistake. I have mental problems. I lied. I said I was pregnant. I wasn't. I need help. I'm going to check myself into a facility. Now, everyone, please leave me alone. And this will go away. We will have one more stream where we will be like, see, we told you so. And this is why you have to look at evidence. And then we will stop and we will cover something else. I'm kind of looking at that Treehouse murder trial. My God, that's crazy. There are crackheads on the stand. It is unbelievable. It is seriously. And a guy representing himself at a murder trial. It kind of doesn't get better than that. Legal vices. Have we determined whether she was stabbed in the stomach? So far, Jeff, there has been no evidence of any knife fights. But if there is, that could be some explanation. Okay, so. Man, the chat is distracting me. I want to read the chat. I want to stop hosting the show and just read the chat because you guys are so funny. You guys are so funny that I just love you. And I want to just read what you're saying. And I feel like I miss out on a lot of the show because I can't read the chat. And I feel left out sometimes. I feel left out from the chat. Damn it. Oh no, there's all kinds of memes I missed on locals. Oh my god, these things are so funny. All right, I'll have to catch up on that later. I've missed out on 3 side stories at least. I know. I'm being left out of my own chat. God dang it. League of Vices. It should be called Blow Fun because if it's a job, you're probably doing it wrong. Jeff, this comment just shows you've never done it. We know you're hetero. Because let me assure you, it's a job. It's a lot of hard work.
That's what she said.
Extra large and extra hard.
Wait, that was a blowjob joke. I get to check off my bingo. That was a blowjob joke. I did it. I did it. Well, it does. It just proves you've never done it. Because let me tell you, there's jaw strength and endurance involved. Anybody who's ever done it knows. You know. The ladies in the chat, they know. And some of the gays in the chat, they know. If you're doing it right, it's a lot of work. Oh. Okay, moving on. Oh my god, you guys are so funny. You're killing me. Hold please while I read the chat and enjoy you guys for a minute. I'm young. This took a turn. Wait, the worst part is I think my 17-year-old is in the room. Hopefully she's sleeping at this point. I swear to God, sometimes I wish I could just be in the chat. But then who would be running the show? Dang it. I know, right? Nobody wants to hear their mom talk about this. Okay, let's move on. We have a very open relationship, Nick. We are very close. Oh man. Okay, I'm broken. You've broken me. The chat has broken me. Where is Flux? Why isn't she here? She would be dying right now. Okay, I'm a professional. I'm getting. Let's get my professional card on. Let's go. Okay, to be fair, she laughs at me a lot. She thinks I'm funny. I'm pretty sure she's sleeping though, because if she wasn't sleeping, she'd be laughing and snorting right now. She's the one who taught me all the "that's what she said" jokes. So Isn't this what the left says we should have? What kind of relationship we should have with our children? Where we talk to them about all these things. All right, moving on. Stop it. Stop it. All right. Respondent is consistently using his social media platforms. Oh no, how dare he? How dare he? To control the narrative of this case. I will remind you that Ms. Owens used her Facebook platform to say that she was not in control of this narrative. And the only way she could control it was to make a social media post. Remember that? She was controlling it before Clayton Echard started using his social media. She went to the media first. She went to the media first. Nick, shut up. I know you will. This stream is going to go down in history as an epic stream. What 17-year-old? It's true. The kids teach me things. All right. It's a new world, folks. You got to talk to your kids about all kinds of stuff. Because if you don't, they're going to hear it from their idiot classmates, okay? So might as well hear it from you. I am the cool mom. They can talk to me about stuff because they know I'm not going to freak out. We usually just laugh about it and we do a bunch of these jokes.
That's what she said.
Can't wait for Reddit on this stream. I know, right? Oh, I have to get on an airplane tomorrow. I'm not looking forward to that. I hate flying. Damn it. It's late. Okay, let's move on. We got to get through this. Respondent is an American television personality. Yeah, that's why you targeted him. Best known for his appearance on 2 seasons of The Bachelor, Bachelorette. Respondent has approximately 360,000 social media followers across Instagram and TikTok alone. Well, it's not that many. Nick Rekieta has more than that. I mean, it seems like a lot, but I'm always surprised that, Nick Rekieta's got 500,000 followers on YouTube, and most people I talk to have no idea who he is. And that's 500,000 followers, you know? My son thinks that my 25,000 subscribers on YouTube is a big deal. It's literally not. It's not that. I love you guys. I'm thrilled that you're here, but it's not a lot of people. It's a very small niche audience, you know? We think that everyone's talking about this, and the truth is that it's not that many people. All right. See Exhibit 3. Respondent has also made appearances on multiple interviews. I've only seen him on one. Or podcasts throughout this case where he's discussed this case situation. Okay, he was on with Nick Viall, and I think he was on with Dave Neal. As a result, petitioner has been the subject of disparaging comments. Oh no. Oh no. But did you disparage Clayton Echard, Laura? Did you disparage him in The Sun? And in Page 6? Because I think you did. Subject of disparaging comments, harassment. No, false.
Wrong. You are fake news.
Annoyance. It's not harassment for people to tell you their opinions, Laura. It's not harassment for people to talk about what you've done publicly, what you've filed in court, and to say that we think it's a bunch of bullshit.
Bullshit.
That's not harassment. It's just free speech. Annoyance and undue scrutiny. Undue scrutiny? What's undue scrutiny? Is that a legal term? Is that a thing? I don't think that's a thing. Undue scrutiny. It's not undue. Yeah, the next Fetal Attraction stream definitely has to have a bingo square that says Megan has tech problems. That should even be the free square, maybe. But it should definitely be there because that's a given. That's going to happen. This deliberate undue scrutiny from tens of thousands of individuals online. For one, it's not undue scrutiny. It's just scrutiny. It's due scrutiny. Is that a phrase? Due scrutiny. You are This case requires public scrutiny. You have publicly accused someone of terrible things. And so the public has a right to then look into those claims and have opinions on those claims. And we find them not credible. This is not undue scrutiny. It's actually completely understandable scrutiny. What's the opposite of undue? It's due scrutiny. Is that a phrase? We need to make it one if it isn't. This deliberate effort to shape public opinion, no, it was a deliberate effort to defend himself from your claims, your public claims. Clayton Echard was never going to go public with this. Yeah, warranted scrutiny. That's a good one, Jingleberry. Warranted scrutiny. She was always going forward with this first. So he's defending himself, and now she's claiming that it's a deliberate effort to shape public opinion when she's the one who went to the public first to shape public opinion. Long overdue scrutiny. Ah, perfect. Perfect. Exactly what I'm trying to say. Good job. This deliberate effort to shape public opinion has created an environment that is not only emotionally distressing,
emotional damage
for petitioner, but also poses, and by the way, emotional distress, you brought that on yourself, but also poses a potential threat to the fairness of the legal proceedings. No, it doesn't. The judge has no idea what's going on out here. Just no clue. Petitioner desires, I mean, how would it cause unfairness in the legal proceeding? It makes no sense. There's no jury, so there's no jury tampering. Petitioner desires to litigate this case on the merits. Oh, do you? Well, then where are the fetal death certificates? Where are the medical records? Free from ongoing concerns that she will receive further annoyance and embarrassment from the public, should aspects of the disclosures and or her deposition testimony be freely disseminated to the public. I love this footnote. This is so funny. Footnote number 1. Pay attention, folks. This is hilarious. Counsel notes that specific instances of online disparaging of petitioner are not included in this motion, as counsel believes this would only encourage the conduct for the people following this case. He knows us. He knows us. I have to say, this is actually a good call. What's his name? Something Keith? Corey? Corey, this was a good call. Not naming us in this motion was actually a really good call. You are smarter than Jay Hatch's lawyers. You are smarter than Johns Hopkins all children's lawyers. Because you didn't put us in this motion. And if you had put us in this motion, you're absolutely right that it will just encourage more people to talk about it, look at it, see it. So good on you. Good on you. This is actually a really good move for her attorney. I'm actually now, my opinion of him has gone up a bit, because I think that Corey Keith is smarter than Ethan Shapiro, because Ethan Shapiro did the unthinkable and he named us in their motions. That is unthinkable. Don't ever do it. Those of you attorneys out there, if LawTube gets a hold of your case, never ever put us in a motion, because it will ensure that not only will the person you named in the motion be streaming about it, but like the entire LawTube community will go crazy and they will pick it up and they will make fun of you and they will make it, they will blow it up. It will just, you can't, don't do it. So good on you, Corey Keith. Good on you for being smart enough not to name the YouTubers talking about this, because all it does is give us content. So yeah, that's smart. Really smart. smarter than Ethan Shapiro and Johns Hopkins All Children's team, who I'm sure make tons more money than Corey Keith, who claims he's a discount attorney. So it appears that Johns Hopkins maybe should have hired Corey Keith because, yes, discretion is the better part of valor. Yes, this is actually a really smart thing to do. And I just want to point it out and give Corey props because it would be a bad idea. It is a bad idea to name YouTubers and lawtubers who cover your cases in their motions because it's a bunch of sour grapes anyway. And I like what he says here. To the extent that this court deems it appropriate or necessary, counsel will provide the court with specific instances of the public comments which are annoying and embarrassing petitioner across social media and online platforms. However, any such disclosures should be protected under seal or revealed via in-camera review. Well, that I disagree with only the judge and attorneys present to avoid worsening the continued impact of this case to petitioner. And the reason why I say no, I disagree with that is because there is nothing that has been said online that I'm aware of that actually meets these categories. It's not harassing. It might be embarrassing or annoying, but I don't know. I'm not even sure. But she did this to herself. The only reason why we're talking about it is because she went to the media. If she hadn't done that, we wouldn't be talking about this at all. So, yeah. Here's your consequences, Like you fucked around and now you're finding out. And like that's unfortunate, but there is an entire community out here that is interested in court cases, especially interesting ones that have celebrities in them. And like, so you fucked around with a celebrity, you lied about all of this, and then now you want to find out. I believe she lied. I think she lied in a lot of these instances we can see. While petitioner concedes, and this is funny, that she also made comments to organizations, these efforts were in an attempt to clear up the many false narratives circling publicly. This is a lie. There were no narratives publicly before she went to the media. And there are emails of her saying to Clayton, if you don't date me with intention, I'm going to the media to tell them that you're not going to support me in these babies or whatever. This is crazy. While petitioner concedes that she also made comments, he should say that she went to the organizations first. She went there first. And how could they be in an attempt to clear up many false narratives when the very first time the public heard about this was when she went to them? She went to the press. This is insane. This is not true. And her lawyer, Corey, I don't know if you know this, but you need to look at the timeline. The timeline here is she threatened to go to the press, and then she went to the press. That's called extortion. And Clayton Echard got a harassment order against her based on that extortion. So the idea that somehow there were false narratives circulating, there were no narratives circulating until she went to the press. None. And Clayton has said he would never have gone to the press with this. The only reason why he comments on it is to try and clear up all her bullshit, her false narratives. The court should limit the method of respondents' discovery abilities. The only issue remaining in this action is the issue of sanctions or attorney's fees. It is undisputed that the parties do not share a child, oh boy, in common. How come it doesn't say do not share twins? Why doesn't this say twins? She's been alleging all this time that they're twins. And no twins. I don't get it. Now it's a child. It is undisputed that the parties do not share a child in common. Well, is it undisputed? Because she went for months and months and said that she did share a child, 2 children with him. So it's not undisputed because she said she did. And that petitioner is not presently pregnant. Well, isn't that convenient? A deposition is unnecessary to seek the information a respondent would require to properly litigate the sole remaining issue of attorney's fees. That's the sole remaining issue? No, it isn't. Sole remaining issue is actually shit, do I have the wrong Rumble stream up? I do. Oh my God, I've missed all the Rumble chats. I had the one from earlier today up. Damn it. I'm sorry, Rumble. And now if you have sent any rants, I didn't see any of them. I'm so sorry. All right, hold on. I'm popping out the right chat now. I'm sorry, Rumble. I had the wrong chat up. I was like, that chat looks familiar. All right. Hold on. I have to fix this. I have problems. Okay. A deposition is unnecessary. Oh my God. No, it's totally necessary. I'm sorry. That's no.
You are fake news.
Wrong.
Is unnecessary to seek the information respondent would require to properly litigate the sole remaining issue of attorney's fees. Oh, no, sir. The sole remaining issue is not attorney's fees. The sole remaining issue is, was she pregnant and were they his kids? Period. Those are the two remaining issues. Was she pregnant? Did she have, and was he the father? The idea that the sole remaining issue is attorney's fees is insane. Respondent refused to agree to enter into any preliminary protective order prior. Good. He shouldn't. Causing necessity for filing of this motion. Given respondent's mainstream history of divulging information related to this case to the masses, he spelled masses wrong, the masses. Without issuance of a protective order, petitioner anticipates portions of and or her deposition as a whole will be discussed and or disseminated publicly. Yeah. Thus subjecting her to additional annoyance or embarrassment. But if you subject yourself to the annoyance and embarrassment, it's your own damn fault. It's your own damn fault. Let's go down to the footnote. There's a footnote. Counsel notes that in his limited time on this case, substantial amounts of information have leaked to the public or media within hours or days of the information being transmitted. This includes not only things like motions, but also emails between counsel and other details surrounding the case as well. Well, sir, Corey, all of these motions have been filed on a public docket. All of them. They're not sealed. They're not private. Nothing is. Look, I had a conversation with Maricopa County. I was told that I could, for $30, get the entire case history on a jump drive, which I should have said, yes, I want it. Please send it. But I just haven't had the time. So the idea that this stuff is being leaked to the press, it's not leaked to the press. It's public. And as an attorney, you should know that. Emails, I don't know any emails necessarily that weren't attached to motions that we've seen. I don't think we've seen any emails that were not attached to motions filed on the public docket. So this is garbage. Petitioner believes discovery can be completed sufficiently through alternative means, including the use of uniform and non-uniform interrogatories. What's an interrogatory, Jeff? What is that? I don't know what that means. It's a big word. It's a $10 word. The request for production of documents, a written deposition, cross-examination, or other means. 3, if the court does not preclude the parties from conducting depositions of the opposing parties. Let me see if I understand that. I have to read that again. If the court does not preclude the parties, okay, so Owens and Eckert, from conducting depositions of the opposing parties, the court should limit the scope of the depositions to the present matter. In the event the court does not outright deny the party's abilities to depose the other, the court should limit the deposition to the issues narrowly involved in the present litigation. Petitioner believes this should initiate with the party's act or alleged act of sexual intercourse. But there was no sexual intercourse. There was fellatio, and I now get to check off that box on the bingo card. We have gotten to the fellatio part of this motion. In an email exchange between counsel, respondent counsel has expressed intent to depose petitioner regarding her previous relationships, which are entirely unrelated to this matter. Oh my God. Has he read the previous relationship info? Because, sir, Corey, it is so related to this matter. Some of it is identical to this matter. We have bingo twice, by the way. We only have 3 squares left. I don't know if we can do it, though, because there is no warrant. There's no warrant issued in this case, unfortunately. 4, the court should issue an order designating confidentially deemed discovery as protected and confidential. The present case is unique. Well, that's true. It is unique. This court is aware of the constant struggle within Arizona courts and laws weighing the best interests of a child against the privileges designed to protect communications with certain professionals. While this case is still labeled as a family court case, the parties do not share a minor child in common. Oh my God, that's what this whole case is about. And therefore, there is no obligation for petitioner to share protected or privileged information. What? Almost all the requested discovery to date seeks otherwise privileged information from petitioner, while petitioner concedes that disclosure of certain medical records may become necessary to support her claims. She's uncomfortable disclosing such personal and private information without a protective order in place. Even then, petitioner should only be required to produce evidence establishing the viability of her claims instead of all medical records or HIPAA releases, as respondent has and will likely continue to request. As far as I know, they have only requested the pregnancy records, of which we think there are none. Conclusion: for the reasons set forth, issuance of a protective order is necessary and can be accomplished without any material prejudice to either party. As such, petitioner asked this court to sign the proposed form of preliminary protective order attached hereto as Exhibit 1. Doing so will protect parties from additional embarrassment and annoyance while allowing this case to be decided on the merits. I am going to forward these documents over to Legal Vices. He will read them. There's more in this. It's like the order that they write up for the, so-called sealing or whatever. And I'm not going to get to it tonight because it's too much and I need to get rest before I have to travel tomorrow. So I will forward everything to Legal Vices and he will pick this up when it is convenient for him to do so, and he can read the rest of it. But dang, this is crazy. This is crazy. And I just say nonsense. And if she's allowed to do this, if she's allowed to seal this from the public that now has a public interest in knowing what is the truth in this case, it will be a miscarriage of justice. Unlike any miscarriages she claims to have suffered, which I don't think happened. Yeah, Jeff, I'm out. It's too late for me, and I need to finish packing and get ready to go. And I still need to rent a car. Dang, I gotta go do that like right now. So, you guys take care. I hear that Nick is streaming, so why don't I redirect you over there? Hold on. Hold, please. While I find the stream I want to send you to. Oh, he's still not live? It's almost 1 a.m. All right, well. Man, he's still not live. He's so late. He's so late and gay. Holy cow. 12:47. He set it for 12:20 and he's still not there. That's funny. Okay, well, I'm redirecting you there anyway. And hopefully by the time my outro is over, he will be there. So you guys have a wonderful evening. Have a wonderful weekend. I'll see you later. And follow me on Locals, meganfox.locals.com. And that way you'll know what's going on. And if I find anything new, that's where it's going to be, because I'm going to be traveling. So streaming's going to be pretty hard. All right, see you later. Wait, how hard?
Extra large and extra hard.
That's what she said.
See ya.